Oh. Greetings. How are you guys doing today? Excited. We got class tomorrow, so if you haven't joined yet, be sure to do so. I'll post a link in the after the video up above and as well as below. So excited for that. But there's some people running around a bit contentious because they don't quite understand how it works, how the system is designed. And I'll be really honest with you, it's really not as difficult as many people make it. If you understand contract law, you absolutely can prevail. And the other thing is, now you can start to navigate this sea of commerce, and you'll realize that the waters are not near as treacherous as everybody would lead you to believe. Many people try processes and fail and don't acknowledge failure as part of success. And what they really need to do is, upon failing, they need a finding of facts and conclusion of law that the alleged judge rest upon in order to make his conclusion. And very seldom do you ever hear anybody bring up that issue. And it's an issue that is relevant. People should take the time to always inquire about the finding of facts and conclusion of law that the judge may or may not have used to render his decision. And it may help you in your appeals process. Remember, in the lower court, everything that you're doing in a lower county court or district court is ultimately for the end game and goal of taking up in a court of appeals, appellate level. So everything you're doing in the lower court, even though they're overruling you and that they're ruling against you and they're making egregious errors at law, which is really a abortion of justice or a miscarriage of justice, grants you the ability to go to the appellate level and to reverse the decisions of the bad actor, and provides a place where you can find remedy in monetary damages or so on and so forth for wasting your time. The prosecutor obviously bringing frivolous claims for which relief cannot be granted. But even better than that, ladies and gentlemen, is invoking the IRS to come in and put the big demon on the little demon and just watch them squeal. And so it's important to know that under the IRC code, the Federal Reserve Title 12, subsection 411, which is actually in the USC, there is no money, ladies and gentlemen. The illusion of money is a figment of man's imagination, or what he will or will not accept, okay? The people are the line of credit, and we find that to be true in McFadden 1932 through 62, where it was conclusively proven that the American people are in fact the creditors, okay? Who is furnishing the bond for the beneficiary's interest, okay? None of the cases are ever bonded. Then, of course, if you don't raise the issue, you waive the issue. So it's important to always compel and command them and require of them to put up a bond for no less than $1 million, $100,000, $1.5 million, wherever you really feel comfortable making them perform at. And so every court is in fact a tax court. It's a taxable determination that needs to be made on the carryover basis, okay? Who is furnishing the bond for the beneficiary's interest? Signature is the collateral on everything. Your signature is the collateral. They're monetizing your signature. Your signature is the value, and it is also the collateral. The courts are involved in insider trading, ladies and gentlemen, and I'm not the first one that's ever going to tell you this. There are many of us out there that have become extraordinarily learned and see it for what it is, and they're practicing on the insider trading end of deals. McFadden 1932 through 62 is case law that sets precedent that the American people are in fact the line of credit. They are the creditors, and you can't rightfully be a debtor, and if you're not a debtor, then the tax liability doesn't fall on you. If you look at Title 26, 2603, 2203, and 2002, you'll quickly realize that you are not the one liable for the taxes, because you're the creditor. And you can simply file a case with the IRS to get a taxable determination on whether or not you are responsible for taxes, and if they have any authority to tax you. And they will always come back stating that there is no cause of action because you're obviously not, and the case that you've brought forward is dismissed. And they're not just going to directly tell you because you're the creditor, but that's what's inferred from that course of action. All right, that's one of the things I was doing out here in Arizona, is setting up a tax court case. And that way, for the case that I've got currently ongoing right now, we can stave off everything and just wait a little bit and find out if not, the IRS has the ability to tax I, the man, as the creditor. And the answer to that is no. And you guys are about to find that out real soon. So if all court cases are a matter of taxes, then it comes around of being as if the IRS doesn't have the authority to tax me, which is the highest taxing authority in the world, then what say you? Does any lower rinky-dink pissant court have a right to tax me on anything? Absolutely not. Because they're affirming, whether directly or indirectly, that I'm the creditor. And that's why I'm not taxable, all right, or not liable for the tax, because I'm not a debtor, I'm a creditor. So it's important to know who you are. Credit on account is generated from signatures, not property. You know, your mortgage, ladies and gentlemen, what they're foreclosing on isn't your home. It isn't the property. It isn't the real estate. It just simply is not. It's the mortgage, okay? And the mortgage is a false and fictitious mortgage, and that's something we're going to go over in class. Everything is a taxable issue. On alternate evaluation on a carryover basis is the reason why the attorneys and everyone you do business with has the tax liability. And again, we find that in Title 26, 2603, 2203, and we also find that if they're going to bring a case against you in Title 26, 2032, AE 11, they're responsible for having a bond issued out of Puerto Rico, the headquarters of the IRS, in order to even do business with you, ladies and gentlemen. Let me tell you something they don't have. They don't have that bond in place. They're not independently bonded, ladies and gentlemen. They don't have a foreign registration certificate in good standing to even be in that vicinity. Okay, they're operating outside of their jurisdiction. But if you don't waive the issue, or if you don't raise the issue, excuse me, you waive the issue, okay? So it's so important to set precedent right out the gate, okay? I'm not an enemy belligerent combatant of the United States. I'm a friend of the United States. I've done my articles of surrender to the state registrar under 192 of the subsection 192 of the Law of Nations, which means I still have my sovereignty. My derogation of sovereignty is still intact, as well as my right to self-govern, okay? Now, in 2011, Lindsey Graham came out and said that the United States is a battlefield. Okay, the homeland is a battlefield. And with that poignant statement, he told each and every one of us what we had to do. And in 2013, to cement that idea in your head, Justice Scalia, before he died, came out and said that very soon the United States citizens will be rounded up and hauled to FEMA camps. So I don't know about you, but for me and my loved ones, we're taking the affirmative action to ensure that we're not confused with belligerent enemy combatants and rebels known as U.S. citizens, okay? And we're taking the initiative to change our trajectory based upon the facts that we substantiate on record. Whether you do a deposition, which means you go before a notary and you swear under the pains and penalties of perjury under oath that the statements are true and correct to the best of your knowledge, and you go ahead and point by point lay it out. Affidavits are not evidence. They're merely hearsay until you testify to them, ladies and gentlemen. So for all of you people out there that are trying to tell people all you got to do is an affidavit. An affidavit works. An affidavit is nothing more than hearsay until it's testified to under the pains and penalties of perjury. So what you got to do is do a deposition. And you do a deposition before the notary and go ahead and cement the facts on record. And now you have something that's admissible in court. Okay, so we can get rid of the misnomers about how these affidavits actually work. You want to do a deposition. You want to be deposed, or you want to depose them, whoever you're bringing a claim against, so you can set the facts on record for the case that you're in. But again, everything is a tax liability. Please review Title 26, 2032 AE 11, all right? Most attorneys and judges don't know about this information, okay? So now you hold the keys. I am showing you where it's at for absolutely nothing. I want nothing in return for helping you out today, to help you ascend to the mind and to give you a little bit of comprehension and how to stand. I don't provide legal advice. I'm not a lawyer. I won't do your process for you. Your words have to come out of your own mouth. The words that go on the paper have to be from your intellectual knowledge and superiority and knowledge, and you have to stand with conviction, all right? But I can direct you where you can find this information. Attorneys and judges don't know about this. However, all men are responsible for knowing the law because all men are responsible for knowing the contracts they enter into. Thus, ignorance of the law excuses no one, especially somebody that went through 7 years of law school, spent 180 grand in schooling, and graduated and passed the bar and yada, yada, yada. The ignorance of the law is no excuse for these people because it damn sure isn't for you and me, all right? So it's time to get with it. It's time to start doing preventative maintenance, ascending of the mind, and putting the screws to these people. And you can do it. I do it, so I know damn good and well you can do it, all right? Because I believe in you. And you have to believe in yourself in order to be able to do this. I lost everything. Once I lost everything, there was nothing left to lose. Then I had everything to gain, all right? And that's the important thing. A lot of people are too nervous to do this because they've got some materialistic things they think they own. But in retrospect, when you pass on, you will find quickly, well, at least your family members will, that you own nothing, you didn't preserve it properly, you didn't put it in a trust, and now the lawyers are devouring the carcass of your life source energy, of what you manifested into existence through your dreams and sweat equity. And they're going to come in like vultures on the side of the road with roadkill, and they're literally going to pick the carcass clean. And you know what your family members get left with? Taxes. That's it. Taxes. But if you structure it properly, you don't have to worry about that, you see, because they're the heirs and the beneficiaries of what you created and manifested into existence with your mental fortitude, your sweat equity, and your energy. Okay, so let's stop these jackals, these hyenas, and these vultures from picking our carcasses long after we're gone. Okay, and the way we do that is by letting them know who we are and preserving everything in a trust, controlling everything and owning nothing. Remember, an owner carries liability. You don't want the liability, okay? Let the trustee handle that. Okay. Everything is a tax issue and alternate carryover basis. Please review Title 26. All right. However, all men are responsible for knowing the contracts they enter into. No man is above the law. That's very, very important. You know, I once had a judge tell me I didn't know the law, and I quickly spouted off. Thou shalt not steal, thou shalt honor thy mother and father, thou shalt not murder, maim, or rape, thou shalt not covet thy neighbor's wife, nor his earthly possessions, thou shalt have no other God above God himself, and thou shalt not bear false witness against his fellow brothers and sisters. And when I got to that point, I had made such a profound statement at that point, I simply looked at him and said, I know the law. Need I continue, or shall I digress? And he instantly stood up alongside his chair and said, this court is a constitutional court, and this court will abide by the Constitution. You want to talk about sweet music to my ears, all right? But I said that with conviction. I didn't say it weak-hearted. I know the law, okay? The law was not written for a righteous man, meaning the law of the Pharisees, Roman civil law, martial law, martial rule, rule by military forces and admiralty, does not apply to me. It doesn't apply to you. Are there some good regulations within there to live your life by? Perhaps. Most certainly. There are some things in the code that I agree with. Why? Because they're lawful as well as legal. All right? Murder, for example. 100% agree with it. All right? Murder is innately wrong, and it's positive law, and unanimously across the board, even in the Bible, the good scripture tells us that we are not to murder. It does say, however, there is a time to kill. All right, so you have to be able to make that cognitive distinction in your mind about the difference between murder with ill will, malice, and intent, and the preservation of life and a time to kill. There is a time to kill. This is just what it is. Now, I don't advocate violence, but I think it's important for you guys to be able to distinguish between the two of them. There is a time to grab your sack of rocks and stand up and hit somebody over the head that's threatening your daughter, your family, your way of life. There is a time for that, okay? And that's exactly what the Founding Fathers did. If the Founding Fathers could see us today wearing masks, running around, following provisions and policies, I think they'd have half the notion to whack us all over the head, or evict us from their great land that they tried to conquer in the name of freedom, justice, right? They definitely wouldn't be putting up with nobody trying to put a shot in them. I think the founding fathers would say, you stand in line first, we're going to shoot you up with some lead, and if you survive it, then you can shoot us up with whatever the hell you want to shoot us up with. But there'll be more about that commercial liability later. I may touch on it in class as well, because the vaccination thing is a very, 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 very scary thing. Ladies and gentlemen, if any of you actually believe the government gives two shits about you, you're on crack. You're smoking some damn good shit. Because here's the fact of the matter. If they really cared about people, they wouldn't be charging $1,500 for insulin and giving you free vaccinations that they haven't even tested on rats, for fuck's sake, at Walgreens. And incentivizing it with lotto tickets, reduced speeding tickets, just all kinds of mamby-pamby shit they're throwing in there. Free hotel rooms, trips to Vegas. Are you kidding me? That's really what you're doing to incentivize people to come down and take this mRNA? That's insane. It's insane. And yet the poor people who are on insulin, they can't afford their insulin, don't have insurance, are really in a tight spot. So if they really cared about life and the preservation of life, ladies and gentlemen, the things that I speak of should be ringing through true in your mind. It's not that damn hard to figure out. They don't care about you. It's a big club. You ain't in it. All right. So what can we do? We can gain an ascent of the mind with a specific set of knowledge, and now put these servants back in the box. It's time for them to go back in the box, and it's time for them to work for us, not against us. It's time to separate ourselves from that U.S. person and let them know that we're the beneficiaries of it. All right. Real simple shit. And I mean, take no shit from nobody while you're doing it, okay? These people can presume and assume all they want until what? Until the creditor stands up and sets the record. And that's what it's really about. They're looking for the executor. They're looking for the creditor. And everybody wants to go in there and start arguing, create controversy, otherwise where none exist. Because remember, in order for facts to be established on the record, they got to be deposed first. And ain't no prosecuting attorney being deposed on shit. So it's all presumed and assumed that you're the debtor, all right? Let's get in here. If you have a qualified heir, that makes a written application to the Secretary of State for the termination of the maximum amount. The agents bear the responsibility of the taxes for charging up the estate. Isn't that something? All right, and that's found in Title 26. They're liable for touching the estate. They're now appointed fiduciary executors carrying the liability for paying the taxes. And this is something that you're not seeing many people talk about. And Mr. Anonymous keeps drilling this into my head. Derek, sometimes you want to go to war. But I'm telling you right now, just put the big demons on the little demons and sit back and pop a bag of popcorn and grab a glass of water and sit back and enjoy the shit show, because it is funny to watch these people squirm when they're talking to the IRS trying to iron this shit out so they don't lose their home, their cars, and possibly get thrown in jail for tax evasion. All right? Bear the responsibility of the taxes for charging up the estate. Why? Because they never bonded the case. That's right, ladies and gentlemen. Because they didn't bond the case, now they're independently responsible for it. And the taxes, okay? The agents are claiming to be the qualified heir, and they are not. But if you don't raise the issue, you waive it. Kiss that goodbye. They're hoping you'll never retain what I'm telling you, ladies and gentlemen, which has taken me years to ascend to the mind and gain this acquired knowledge that absolutely works. It works, all right? I'm not blowing smoke up your ass, expecting some unicorn to come down and shit rainbow sherbet, all right? That's not what I'm doing. I'm telling you what works, okay? Through trials and tribulations, this is the stuff that I have found that absolutely works and just sets fire to their whole reign of terror. And at the same time, you can be at peace. There's no need to be hostile. There's no need to be angry. Let the big demons take care of the little demons. The agents are claiming to be the qualified heir, and they are not. So, how do we catch them then? Discovery, ladies and gentlemen. We depose them. We ask in discovery for them to produce the facts and evidence on the record that the case has been bonded independently for $1.5 million, that they have the required bond out of Puerto Rico to even be involved in the case in the first place, and they don't. Okay, and that makes them personally liable at that point. So now we want a 433A and a 433B to get a list of their personal assets as well as their business assets. Because when we find out that they're not independently bonded, which is required in their own damn code to be bonded with Puerto Rico and the IRS, the Internal Revenue Service. When we find that not to be true, that they have not been bonded through them or have a bond in play in Puerto Rico and the Internal Revenue Service, now they're 100% personally liable. There is no escape for them, okay? Writ of discovery. Do you have the tax liability? That's what you're going to ask them. Do you guys have the tax liability under Title 26, 2203, 2002, and 2603? You guys carry the tax liability? Yes or no? Okay? The only answer to that is yes. Why? Because whoever has decedent estate property is liable for the taxes. What do they have that's the decedent estate property? Aha! The performance bond, the bid bond, the payment bond, the warehouse bond, the original issued ticket, which is really a security, okay? They have it all. They have decedent estate property, and they're 100% liable for it. So put the liability back on them. Ask the right questions. Make sure that when you do it, you smile. Hey, I'm just here to assess taxes. There's no facts in dispute. Why? Because nobody's been deposed. There's absolutely nothing on the record but a bunch of gibberish. He did this, or he did that, or he did this. Well, for fuck's sake, what did he do? Nobody knows, because there's no facts on the record. How can you face a witness when they can't even produce an accuser? All right, or a victim furthermore. That means that the witness is a bold-faced liar. Liar, ladies and gentlemen. So many people struggle with this. And this is why I continue to do these videos to help you guys out, because I really want to see this country turn around. And we got the power. We got the brain power. We got the mentality. There's never been a better time than now. And it's not just here in the United States of America. When I say the United States of America, make no mistake, that comes from the Articles of Confederation, Article 1, Section 1, where it clearly outlines that the United States of America, in quotation marks with a period, is exactly how you identify the United States of America. Not King George's United States of America, and not the United States, completely separate entities. This is pre-Constitution, ladies and gentlemen. And you're going to bring yourself back there through equity, and you're going to stand on sound doctrines and principles of the Heavenly Father and the maxims out of the book, out of the Bible, the best book in the world. Do you have the tax liability? You're going to ask them. Yes, they do. Of course they do. Why? Because I just explained it to you under Title 26, 2603, 2203, and 2002. Go look them up. All right. And then also, they're required to carry a bond with the head of the IRS out of Puerto Rico. All right. And that is also found in Title 26, 2032, AE 11. You can't beat this shit. They can't get around it. Al Capone couldn't get around it, ladies and gentlemen. They can't get around it. They may claim 11th Amendment immunity. Ladies and gentlemen, nobody's immune for taxes, right? Because don't we all wish to be in voluntary compliance with the Internal Revenue Code? Right, Judge? Just give him a nice smile. Right, Judge? We all wish to be in voluntary compliance with the Internal Revenue Code. Is that not right? Why? Because they are the ones bringing the false charges, okay? And that's why they're responsible for the taxes on it. Series of questions here, just to put them in your mind so you can start thinking about this, guys. This shit it's just amazing. Am I a decedent? Simple question. Yeah, you get one of those jackasses to answer, and they can't. They can't do it. Have I accepted the liability of the decedent? Am I the debtor? All right. Am I not the beneficiary of the estate? Now remember, we don't ask questions that we don't already know the answers to. But we put the onus of probandi back on them. Why? Because they're the ones bringing the fucking claim. Nail them on it. When they ask you, how do you plea? Shit, I plea I hope this jackass over here falsifying a record to extort my estate can prove his claim, and also is paying the taxes, because he who provides the ends provides the means. So if he brought the claim, I hope he brought the check too. Huh? Yeah. How do you think about that? What do you feel about that, all right? Do you bear the tax liability for your alternate evaluation on your carryover basis? You're going to ask him that. Okay? This is all stuff I dropped the last time I was in court. Unfortunately, they told me that it was special, and they lied to me. All right, they lied to me through a deputy sheriff, so they got plausible deniability saying, oh, we never said anything like that. We never told you it was special. Okay, I'll give it to you. But from now on, no more being nice. You guys want to play with me? I'll play with you a little bit. But the way I play isn't so nice. And there is no plausible deniability for you at this stage of the game. Not anymore. So, and I've got more than just one way of hammering them. I'm not just going to hammer them with Title 26. That's child's play. That's child's play. We're talking RICO. All right? We're talking false and misleading statements. Carries a fine of $25 million and 10 years in prison. All right? There's some serious shit going on here. All right? We're talking the fact that none of them are currently registered with the Foreign Registration Act of 1938, amended in 1939. They have no right, rhyme, or reason for being on my soil, trying to fleece and extort me under threat, duress, and coercion. Big mistake. All right. That's where Form 56 comes in. Form 56, Form 56F, appointed fiduciary trustees, and just sit back and watch the shit show. Go ahead and grab their EIN, do a 13909, a 3949A, a 4506A, and a 211 form so you can collect after the IRS rips these people apart and finds out that in their books they've been scheming and scamming for years and not paying no damn taxes on the carryover basis of everything that they generated, while holding the liability because they have the decedent's property in their hand, in their care and custody. And that's what makes them liable. Do you bear the tax liability for the alternate evaluation on your carryover basis? Did you put up a bond for your tax liability? Did you go ahead and notify the Internal Revenue Service in Puerto Rico that you were going to put a bond up on this case? I don't think you did. I can't testify for you, so I'm not going to say you didn't. I'm just going to say I'm calling into question whether or not you follow your own rules, regulations, and procedures. And so far, I haven't been proven wrong yet, which means no, they don't carry it, all right? And you can hem them up on it. Are you making a claim on my estate? Because as you all know, you can't be the all capital letter name. I mean, you can if you want to be. If you want to be playing make-believe all day long and pretend that somehow that you're the estate and that you're the all caps name and you know not who you are, well, who am I to tell you otherwise, right? I'm not going to argue with you. If you believe that you're a name and you could be a name, then by all means be the name. I'd much rather just be the beneficiary of the estate that was manifested for my benefit because of what they did in the banking sector back in 1933, 1913, 1907, 1929, all the way back to Abe Lincoln and beyond, all right? Creating this fiat system and taking everything out of circulation that had any real substance or intrinsic value, and pumping in paper into the economy through private organizations, somehow alleging that I have an obligation to pay taxes when I am in fact the only true creditor, period. Are you making a claim on my estate? Have you given up your citizenship? Now that's not a question for you, that's a question for them. Because when they fill those offices, they're now foreign agents and agency, and that's where that question comes in, because they'll deny having to be compliant with the Foreign Registration Act of 1938. But we all know that as soon as they take office, they're no longer United States citizens. They're foreign to us. They're foreign, and they're foreigners operating on our soil. What court of law is this? Are we in admiralty? Are we in maritime? Are we in the exclusive jurisdiction of equity? Are we on the private side? Are we in the public venue? You know, you have a right to know the nature and cause. Well, they'll always tell you the cause because they're lying, looting, pandering pieces of shit. That's the cause. That's the reason. Because we make shit up as we go to fleece innocent people all day long. That's how we do it, baby. But they'll never tell you the nature. Lord have mercy. Could you imagine if they actually told you the nature of the transaction is banking? Yeah, they're not going to do that. They falsified a record to steal from you and unjustly enrich themselves. Naughty, naughty. All right. What jurisdiction? All right. So I just explained a multitude of different jurisdictions, so you want them to clarify for the record. Because how can you protect yourself if you rightfully don't know what jurisdiction this whole bullshit scheme is being operated in? Well, it's being done in admiralty, okay? Which means they believe you to be a subject, slave, or volunteer of their system, but they have no contract in place. Civil or criminal would be the next question. Is it a civil case or is it a criminal case? If it's a criminal case, I demand that you bring the injured party forward so I can provide remedy. I'm just a man here today in honor, just wishing to remain in honor. If there's a man or woman that I've caused harm, injury, damage, or loss to that I'm unaware of, I'd sure like it if they come forward today so I can make restitution, go ahead and make right with them. Oh, you can't do that? Oh, we're going to have 15 more bullshit court cases because you can't produce a victim? That means you've got no jurisdiction, silly Sally. We're done here. We're done here, almost, except for we still got to do an evaluation on the carryover basis of the taxes for you touching my estate. Ooh, you shouldn't have done that. If it is civil, appoint them all trustees of the subject matter. Why? Because under Title 18, subsection 8, all obligations are obligations of the United States. Appoint them trustees. 63 Charlie M jurisprudence 2D, ladies and gentlemen, clearly articulates and states that they're all trustees of the people. Period. Period. Nail them with it. Stick it to them. Depose them. Get them to testify under oath that they're not trustees. Go ahead and see if they'll do it. Bet they won't. But they won't even come near that stand to try and testify. They'd rather just disappear in the night. But then it's up to you to go ahead and file the proper forms through the IRS to make sure you can remove these rat bastards from harming any more of your fellow brothers and sisters. All right? Civil or criminal, if it's civil, appoint them trustees of the subject matter. Are you in breach of contract for failure to bond this case? Ladies and gentlemen, that's an important question. If you didn't bond the case, are you technically in breach of contract, yes or no? Always ask yes or no questions. I don't need a diatribe of bullshit coming out of a liar's mouth who went to school for 7 years to learn how to bullshit people. All right? I just need a yes or a no. It's real simple. Have you contacted the Treasury out of Puerto Rico and placed a bond in order to operate in this court for this specific case? Yes or no? Simple. Are you in breach of contract for failure to bond this case? Number 10, notice of understanding. You know, we have to ascend to the mind if we're going to come to a contractual nexus or agreement. I accept conditionally under proof of claim, Title 26, 2041, 2038, 2514. Again, that's Title 26, Sections 2041, 2038, and 2514. All right, this is all on the commercial side, ladies and gentlemen. I'm not talking about the exclusive jurisdiction of equity today. I find that it's best to be well-rounded in all realms so you can maneuver, all right? You don't learn jiu-jitsu in the middle of a bar fight. You learn jiu-jitsu so if you ever end up in the middle of a bar fight, you can fend for yourself, all right? So the people that are coming to me going, I got court tomorrow, Dirk, what do I do? Pretty pink knee pads at Home Depot, ruby red lipstick, wear a dress without panties. If you're a guy, walk in there, wear a kilt, and just bend over and go, could you take it easy on me this time, please? Okay? That's the reality of it if you're calling me a day before you got court. Okay? Because all of this needs to be handled. You can also do a corporate denial as well, a notice of corporate denial, and come in there and let them know that you're not a corporation. You know, if the judge enters a plea for the estate and he says not guilty, you ask him, you accept his determination of not guilty, and you ask him if it's judicial or if it's administrative decision that he just made on behalf of the estate. You know, far be it from me to argue with an idiot. I just need to know if that was a judicial determination or an administrative determination. I agree. The estate more than likely is not guilty, but that still doesn't abscond from the tax liability on the carryover basis for you guys generating these securities and bonds under my good name without full disclosure. I'm just the beneficiary here. I just want to see that everybody gets paid. Let's make sure chip top shape, everything runs smooth and looks great, right? Under the Power of Appointment Act of 1951, you can appoint all of them trustees, okay? And also sections 406, 407 of the Uniform Trust Code, all right? I'm going to mention that again. Under the Power of Appointment Act of 1951, you can appoint anybody a trustee. You can do it orally, you can do it in written form, you could use a Form 56F, you could use a Form 56. You could also invoke sections 406 and 407 of the Uniform Trust Code, appoint them all as trustees, judges, clerks, prosecutors, anybody involved, anybody that sets the case, and boom, be like Oprah Winfrey, and you're a trustee, and you're a trustee, and just let it ring off your tongue, and just watch their eyeballs damn near pop out of their head as their assholes suck the air out of the room, because that's how powerful this information is that I'm giving you, all right? They will attempt to play dumb. All right? Don't buy into their bullshit. They're good at playing stupid. Looking at the wall like, I just don't know what he's talking about there, Judge. You better figure it out, Scooter, because jail is not going to be fun for you guys. As soon as somebody recognizes your sweet ass in prison, they ain't even going to ask if you want your cornbread. They're going to take your damn cornbread. You ain't going to get no cornbread. You probably ain't going to get no Snickers bar either. All right? You just be careful over there, lying, looting, pandering lawyer, when your ass ends up behind bars, because them boys going to love you. They will love you. So, they will attempt to play dumb, remind them that ignorance of the law excuses no one and that no one is immune from taxes. You might claim to have 11th Amendment qualified immunity, but I promise you, sweet ass, that you are not impervious from the IRS. There is no sanctuary for what you're doing, unjustly enriching yourself and touching decedent estate property and not paying the taxes on it. The capital gains tax must be paid by them. They are trespassing on your estate. Remember that. Everything manifests from your estate. Why? Because you're the creditor. Every other corporation is insolvent. So you can also ask them if they're solvent and to make them prove that they're solvent. Okay? And they're not. If it goes any further than that, they are trespassing on your estate. Why they ask if you understand, they are attempting to make you liable for the taxes. You never understand a damn thing, ladies and gentlemen. It's wordplay, it's trickery. You never understand anything, okay? When they're asking if you understand, they are attempting to make you liable for the taxes and the bond. You ask them for the 1099 OID, original issue discount. Why? Because they already sold your shit at a discounted rate, ladies and gentlemen. Yes, they did. Yes, they did. And you can ask them for it. And if they don't want to produce it, you can compel them to perform, all right? You can do a forensic audit on their ass. Demand all funds on all cases, including the one you are involved in. Only a beneficiary can file a claim, all right? Men file claims, corporations file complaints. Pay attention to that. I am the executor. I am also the beneficiary. I can wear multiple hats, and I can play in the private realm as well as the public realm. They're envious of me because they can't do it, all right? But they're trying. UCC1 is the claim. A maritime lien is a secret lien. So, with that said, I'm going to go ahead and drop off the map here. Look forward to seeing you guys in class tomorrow. If you haven't signed up yet, I'll post it in here. This is kind of some of the hard-hitting information that I give and do in classes. Of course, in class, there's a slide presentation through PowerPoint. We really hammer home on the processes and what to say and what to prepare yourself for if the judge gets out of line, how to pimp slap them. You know, and sometimes you got to get the baby powder out. I'm not going to bullshit you. Sometimes you got to dust your hand a little bit and backhand them like your mama used to when you was being a shit ass in the back of the car trying to go to Disneyland or something, you know? You know, you ever have your old man say, don't make me turn this car around, Mom, turn around. Yeah, that's what you do to a judge, all right? It's that simple. And you spank them with the IRS. And you don't have to be a dickhead about it. You don't have to be rude and unruly. In fact, you can do it all with a smile. You do it all with a smile. To give them that $1 million pearly white smile and just let them know, shit, ain't no problem here, Watson. I'm just here to evaluate the taxes. That's it. Ain't no facts in dispute, baby. You touch the estate. It's a bad thing to get caught touching the estate, especially when a man knows how to invoke the IRS to get up after him, all right? So think about it. The 3949A, the 13909, the 4506A, the 211 form, the whistleblower form. You want their EIN. You want to know that they're independently bonded, that they bonded the case or they have a bond in Puerto Rico with the head of the IRS out of Puerto Rico. You want to know that they're compliant with the Foreign Registration Act of 1938. You want to know who delegated them the authority to operate outside of Washington, D.C., which is a 10 square mile area. I ain't got that shit either. Ladies and gentlemen, I'm giving you all the ammunition you need to pimp slap these people. And I mean make it hurt. Leave some welts on that ass, all right? So thanks for joining me. As you can see, that's my teaching style. It's hard-hitting. It's in your face. We're not bullshitting. We're not playing around here. We dedicate a lot of our time to doing an extensive amount of research, and I'm surrounded by a plethora of very knowledgeable mentors that help me see a number of different areas of jurisdiction that most people will, one, never find, never learn about, and never even attempt to execute. So the end game is to exercise preventative maintenance, just like you would with your car. You don't change the oil in your car after the engine blows. You change it beforehand to prevent the engine from blowing. Just like you want to be prepared for that bar fight. You're going to learn tactical defense before you ever encounter a situation, hopefully, that you would need it, okay? It's better to have it and not need it than need it and not have it. So for those of you that are in it to gain some preventative maintenance knowledge, wonderful. For those of you that are in the fight with your mortgage and your foreclosure, we've got some remedy for you that if you execute this properly, you can prevail. You can prevail, all right? So I look forward to seeing you in class tomorrow, May 15th, 2021 at 1 p.m. Central Time. It's going to be a great class. It's a $100 donation, and I'll put the link for the class in the video up above here and down below. And I'll see you guys in class tomorrow.